Welcome, Marty, and thank you for agreeing to talk to us for this video, which will also be the basis of a journal, of journal articles. We want to talk to you today about making statements, and in the light of the constitutional right against self-incrimination, I'm wondering if you'd like to start us off by a little discussion of why would a survivor of a violent encounter choose to make a statement to police after acting in self-defense?
I want to make it perfectly clear that I am not giving any legal advice here. In fact, while I have a law degree, I'm not even an attorney. And so there's no legal advice here. What we've got in this video is me, Marty Hayes, telling people what I would do under certain circumstances and explaining a little bit of knowledge about the law based upon my about 40 years working within the criminal justice system, both as a police officer. I shouldn't say both as a police officer. I should say as a police officer, as a firearms instructor who occasionally testifies in court, as someone who has pursued a legal education to better testify in court, and then one who started the Armed Citizens Legal Defense Network 15 years ago, and who interacts with attorneys, while not on a daily basis, at least on a weekly basis, if not more. And so that's where I'm coming from. And I'm going to basically be giving the logical citizen's viewpoint on things.
So what is the logical citizen's viewpoint on why we would give a statement to police? We've got that constitutional right not to say anything. Why would we choose to give a statement after a violent encounter, after surviving something where we had to use force in self-defense?
Well, understand something. You know, the police are going to get a call that violence has occurred. Mm-hmm. Somebody beat somebody over the head with a baseball bat. Somebody stabbed somebody. Somebody shot and killed somebody. And so the police are getting called, and it might even be you making the call, and we'll talk more about that later.
Yes.
But they're going to show up, and they want to investigate what happened. And in order for police to do the best possible investigation, they need to know what happened at the scene. And notice I didn't call it a crime scene because your actions, assuming it was in lawful self-defense, is not a crime. But if they're investigating a crime, they're investigating the crime that the perpetrator was doing to you. And with that in mind, they need to know the information. They need to know what happened. Wouldn't it be nice if on every situation anyone ever got involved with, that there was a witness there to be able to relate to the police what they saw, what happened, what they heard. The good news is there is a witness there, and that is you. And so I have been teaching the following concept for at least 25 years, if not more, and that is be a good witness. The police need witnesses to be able to figure out what happened at any given instance, and you need to be a good witness. And so that is why you might choose to make a statement to the police.
Before we go further, let's tie down some of our terminology, and much of this derives from questions that members phone in, email in, things that they feel some confusion on. So let's just spend a little bit of time on terminology. And let's start with what constitutes giving a statement. How broadly do we define a statement?
A statement is any words that come out of your mouth or any physical gestures that would communicate to the receiver of the statement what you are intending to accomplish as far as what happened or, you know.
So let's break that down a little bit more. There might be different points in this post-incident timeline where you might be expected to make a statement. That goes back to your be a good witness, just be a good citizen idea. When you might be expected to, I mean, responding officers may expect you to make a statement to them. Meeting with investigators with your lawyer present, of course, you're going to be making statements. There may be a walkthrough of the scene. There may be a chance or informal meeting with the detective. Hey, I just wanted to ask you one more thing. And now are you making a statement to him?
What would you like to know, Lieutenant Colonel?
Are there any other times? Let's talk about some of those various times. Are you making a statement under all of those circumstances?
Yep. Anytime you talk about something, you're making a statement. I just made a statement.
Is it admissible?
Depends on whether or not you wanted to prove that I made that particular statement.
Okay. So are there any statements that a person who defends themselves might make to police that are inadmissible at trial?
Yeah, any statements made pursuant to police questioning after they have read you your Miranda rights and you have agreed not to talk to the police. Then, if they ask one more thing and you answer that, knowing full and well that the police have Mirandized you and you have refused to talk to them or invoked your right to self-incrimination or to not being incriminated by your own speech, then those would be admissible.
Inadmissible.
Yes, like I said, inadmissible.
Gotcha.
Additionally, hearsay statements are inadmissible.
Well, you've mentioned hearsay. What is hearsay?
Let us consult Black's Law Dictionary for that specific definition.
Okay.
Traditionally testimony that is given by a witness who relates not what he or she knows personally, but what others have said, and that is therefore dependent on the credibility of someone other than the witness. Such testimony is generally inadmissible under the rules of evidence. So, that's what hearsay is.
And so is there any time that hearsay would be admissible at trial?
Yes.
And let's talk about those.
There's a lot of exceptions to the hearsay rule. An excited utterance is an exception to the hearsay rule. If during this situation there was a lot of excitement around and you uttered something that another person overheard, they could likely testify in court to what you said.
So they would be saying that what I said was credible, and so it's okay for them to tell the judge and jury that? Is that how that works?
It falls back on the idea that someone who is in an excited state isn't going to be purposefully lying about something. And the whole reason for the hearsay rule is to only allow credible testimony in court. Another of the exceptions to the hearsay rule are statements against interest. Let's say that you're an armed robber and you left the store with a bag full of money and you got into a car and took off and showed the bag of money to the driver and says, "Look how much money we got." Well, if the police want the driver to be able to testify to that utterance, then they would have to reasonably show, I should say, that was a statement against interest.
Oh, yes.
And so the other person could then testify.
I see.
To that.
Are there any other aspects of admissibility or the credibility of statements that we should talk about when we're laying down these definitions and how things work before we move on to dissecting things like what you say when you call 911, what you say when the officers get there? Are there other characteristics of statements that we should explore?
I'm not sure how to answer that.
Okay.
I do know that I've been consulted on a number of self-defense cases, and I have yet to run into any of them where hearsay was a big point of that case. I frankly don't think it's that big of a deal in the armed citizens situation.
Moving away from hearsay then, as far as direct statements that a suspect or defendant made, have you run into any questions of credibility or inadmissibility in the direct statements?
The defense attorney is going to make a cause for the jury why the defendant is credible and when they say that their life was in danger. And that's where a lot of this bullshit that you hear on the internet comes into play. If you have seen a video 100,000 times that says, don't talk to the police, just simply state, I was in fear for my life. I was in fear for my life.
I was in fear for my life.
Then that statement, I was in fear for my life, lacks a little bit of credibility.
It's not original. It's not from your thought process.
Yeah.
It's from something you were parroting.
On the other hand, if the guy says, if the defendant, the armed citizen says, he was going to shoot me, I drew my blaster and shot him first, then that's a little bit better instead of just saying, I was in fear for my life.
Okay, so we're talking about authenticity really
Yeah.
as much as anything.
And that helps, especially if the guy does have a gun. You know, it's laying down on the ground and says, okay, well, that's probably pretty truthful. You know, and also it's better when you've got a witness there that says, yep, that's what I saw.
Yeah.
You know, and so the more and more evidence to back up your statement, the better off you are.
Of course. Well, let's switch on to some places where we might apply the things that we've talked about. And one of the big areas that I feel like doesn't get addressed very much, and yet it's very much a part of what we're talking about, that is, can we accept that if one calls 911, the things told to the dispatcher are going to be, or at least may be, admitted as evidence at trial?
I have yet to see a case where the 911 transcripts were kept out.
Wow, really?
Yeah. There may be out there, again, I'm not an experienced criminal defense attorney, but the reason you would keep them out, the reason a defendant would keep them out would be because they're damning to their defense, at which point then the prosecution would say, Your Honor, that's an exception to the A, excited utterance rule, and B, statement against interest.
Okay.
And so Your Honor would say, objection overruled, they're coming in.
Are you going to make the call yourself? Are you going to possibly have someone else who could make the call? What concerns attach here?
If I do not believe there is any other way to get the police coming, then I'm going to make the call. If there are witnesses, I would say, Mr. Witness, call the police. Tell them what happened here. Send an ambulance. The guy is injured.
If there is nobody but you and the assailant, what are you going to tell dispatch?
I would give them my name, the location, and I would tell them, assuming, let's say it's a shooting call, an armed robbery that you interrupted. I would say there was an armed robbery at 7-Eleven on 2nd and Vine. There is a man who has been shot. The robber has been shot. And we need police and ambulance here.
I have listened to video lectures that included playing some of those recordings, and it seemed to me that the dispatcher was, with no disrespect to our emergency services people, they do a tough job, but it seemed to me like they were pretty much interrogating the guy who called in. How would you react if the questions were coming fast and furious?
I would say, I can't talk right now. I have to contain the scene. And I would hang up.
That flies counter to much of the advice that we're given to remain on the line so that you can be told when officers are on the scene and that type of thing. Is that a blanket response, or is it only if the dispatcher is getting a little intrusive with their attempt to gather information?
I don't know.
Okay, maybe we can just cut that question.
It's just going to be situational.
Okay.
You know, what do you think at the time you should be doing?
Well, I certainly think containing the scene would be. I'm not sure that we always have a realistic picture in our mind. That aggressor may be still a threat to you, and I don't think you need to be talking to dispatch under circumstances like that. But mostly, I think you don't need to be giving a lot of details to the dispatcher and how to shut that down without creating hostility does become a question.
You can see how much of a problem it became for George Zimmerman when he stayed on the line with the dispatcher and talked about the guy that he thought was breaking into the police or into the residences and how he's following them, and then he's not following them, and then he was following. And this really became a focal point of his trial, was his call to 911. Mm-hmm. And if he would have just said, hey, I'm the block watch captain here. There's a suspicious activity. There's a man who is looking like he's going to break into houses. Please send the police. And probably he made a description of himself so they wouldn't think that he's the one breaking into the houses, and left it at that. Mm-hmm. He would say, no, I've got to go.
That makes sense.
And the police would show up, and he wouldn't have been accused of stalking this this young child who had a bag of Skittles or whatever.
Right. Well, that's a good example. I think that one of the bad things that has come out of all of the video and all of the discussion of this issue on the internet is I run into a fair number of people saying, why would I even call 911? And maybe we're not talking about a shooting where the evidence is going to be incontrovertible. But let's say that you drew a gun in defensive display. It worked as the statistics say that it often does, and you were able to diffuse the situation, get yourself to safety. That's as much a time where I hear people saying, why the heck would I call 911 and say what I had done? Your thoughts on this?
Well, understand that if you use force or threaten to use force against someone, you have committed a crime. Mm-hmm. And so if you want to turn the narrative away from you committing the crime, then you need to tell the police what the other person was doing, what criminal act he or she was doing that caused you to need to defend yourself. Mm-hmm. And so it's a matter of turning it away from you. Mm-hmm. Because every time you use force, whether it's pointing a gun at somebody, whether it's shooting somebody, whether it's grabbing them and taking them to the ground, absent justification, that's a crime. Mm-hmm. So you need to be setting up your justification. Now, I will admit that if I'm out hiking in the woods and I come across some homeless dude who gets out of his tent and comes and confronts me, I might simply say, sir, I don't have anything for you, back away. Mm-hmm. After which, if he didn't back away, that gives me more information to believe that maybe there's something more serious going on there, at which point I may put my hand on the gun. Say, sir, I said back away. And he says, oh, dude, I'm sorry, I misunderstood. And he goes and gets back in his tent, and I keep hiking away. I might not call the police under those circumstances. Mm-hmm. It's just going to have to be a situation. I might, when I get back from my backpacking trip, call the police and say, listen, I need to report an incident that occurred. Mm-hmm. I was out on Trail 51 in Gifford-Pinchot National Forest hiking up to the mountain lake that I like to go fish at, and I was accosted by a guy who was obviously living in a tent. And I told him to back away. He wouldn't. I told him to back away again, and communicated to him by virtue of my hand under my jacket that he needed to back away, at which point he backed away and we were done. I just want to let you know there's somebody up there doing this. Well, what did he look like? Well, he was a short guy. He was fairly physically fit, or maybe emaciated, whichever you want to say. He had a blue shirt on, khaki pants, and he had glasses on. And that would be it. Now, knowing the police, they're probably not going to be running up the pathway to Gifford Pinchot National Forest and confronting the guy. They're just going to write a quick one-liner in the dispatch log and move on. But at least you've communicated to the police that this happened. And if at some point in the future he ends up getting shot or he ends up attacking someone, then there's a little piece of information there that might be important in a court case.
So that example was in a very remote situation. I think that it's probably more predominant that you have someone who had to work late and they're trying to get to their car, and they believe they're accosted or put in fear of their lives in the parking lot, just trying to get in their car or get to public transit to get home. What's the downside of not calling to report perhaps a defensive display, just as you explained? I said, don't come any closer, and maybe your hand goes to the gun.
Well,
what's the downside of not reporting that?
Well, you discussed that. I'm reminded of an incident where you ended up having to stop a panhandler at a gas station parking lot. Mm-hmm. And what did you do?
I yelled my head off.
Yeah? Did you show him a gun?
No, I did not.
Yeah.
Because I was never that close to him. He responded to my verbal commands and he staggered off in another direction.
Yeah. Now, if he wouldn't have stopped, if he would have kept coming at you, would you have displayed a firearm?
I would have been moving behind the car and had a hand on the gun. And I think at that point, if the gun had come out, I would have called 911.
Yeah, exactly.
Because there's a lot of people around. You don't need that kind of a report from people who don't.
There's this lady at the gas station waving a gun around.
Yeah, who needs that?
Yeah. So it's all situational,
And yet, I'm hearing from people saying, I don't see why I would call and tell on myself. I don't see why I would call and report this thing that I did. And it's, again, that orientation of who was the actor here. Was I the actor or was the aggressive panhandler the actor? What do I want to report?
It's going to be filtered by your common sense. Is there someone else around that might have seen what happened and might they have thought that I was being out of line when I pulled my gun? Mm-hmm. If that's the case, they may call 911. So there's a crazy lady out here waving a gun around. Mm-hmm. And this is her car. In fact, I've got a license plate number. And within a few minutes, you're pulled over and arrested for making terrorist threats. Mm-hmm. And if you remember the Paul Lathrop case.
Talk to us a little bit about that.
That's the one that comes to mind. Paul's was a truck driver at the point, and he was on a run, and he had stopped to get gas, and he was accosted by another truck driver who thought that he did a poor job of parking. Eventually, the guy said that Paul waved a gun at him, and then Paul drove away. Well, Paul didn't wave any guns at him. He said something to the effect that, hey, listen, back off, guy. I've got a gun, and perhaps Paul might say that he probably shouldn't have said those words, but he did. And the guy then reported that Paul waved the gun at him, and Paul was pulled over 20 miles down the road and arrested and spent 6 months fighting this case until the prosecution dropped the case.
Mm-hmm. Do I call and report something from verbalization? And the terroristic threats charge is coming up more and
Yeah.
more when people do defensive display. That seems to be a favorite among prosecutors at this point. As I recall, and again, it would be educational for people, and we can probably link to the original video podcast that Paul did with another person, with another program, and it makes very interesting information. I believe that the accusations described a gun that was not one that Paul even had in the cab, but it does guide our thinking as to what would I report and what would I just walk away from. Verbalization can be something that you might want to call in just to establish a record.
The fact of the matter is, Paul didn't call in.
Okay.
He said, "Man, that was freaking weird." He gets in his truck and drives away. Well, if he would have called in and said, "Listen, I was just accosted by this guy at the Flying J. I just wanted you to know about it in case something happens to somebody else," like he would have never been arrested. Yeah, because now you've got Paul saying one thing, being the complainant, and then the other guy calling in about it. And well, he might have been arrested, but he certainly would have been pursued as hard as they pursued him because he had made a statement, and they had now two pieces of evidence: his statement and the other guy's statement.
That's worth thinking about. And yes, it's going to be nuanced. There's going to be circumstantials involved. Anything further you'd like to talk about that 911 call or reporting on yourself, as it were, before we move on to responding officers arriving as a result of the 911 call?
Yeah, let's put that all in context of what would a good witness do under those circumstances. And would the witness have called the police? Was it serious enough to get the police involved? And so that's what you need to be, is you need to be a good witness, because you are perhaps the only person that witnessed this situation.
Well, I think that is a good perspective, and there's pluses and minuses for that hold people back or maybe cause people to report things that are frivolous. We're kind of hating on people that we like to call, and forgive me if this is your name, Karens. People who always try to make a case about somebody else's bad behavior. If we see two people fighting in the street, I think that we ask ourselves, gee, should I call 911 or should I just keep driving? And anymore, many of us don't. Is the breaking point that it involved us, not people we were not involved with? What's our cutoff point here?
Well, I think most people now would turn around and get their cell phone out and record the fight.
Without calling 911
Without
first.
calling 911.
That's cold.
Yeah, but it's true.
Okay.
And he runs away. Okay. So, hello there, little girl.
It had to happen eventually. Yes, I love you. Now I have dog coat on my
Get on.
blazer. Okay, enough. Outtakes.